And the third point, and the fourth point, is to do with the Queen's consent and the money resolution, because we went through all this in relation to the previous so-called Yvette Cooper-Letwin bill. You've made rulings on these matters before, but of course these bills are significantly different. This bill is significantly different from that bill on a whole range of matters, and I understand that you have had an opportunity to consider these questions privately with the Clerk of Legislation, I imagine, and I would be grateful if in that context you could give a ruling both on the question of Queen's consent, is it required, and the second question is the money resolution. The issues are there. It is perfectly apparent that vast sums of money are being involved in on a monthly basis as a result of the extension of time under this bill. Therefore, it's at least £8 billion from the period of April to October. Now it's being extended by a further 3 months, and that's even more money.
So far as Queen's consent is concerned, my ruling on Wednesday the 3rd of April at column 1130 was that as no prerogative consent was required for the European Union notification of withdrawal bill in 2017, giving parliamentary authorities and the Prime Minister to take action under Article 50 of the Treaty on European Union, there was no requirement for new and separate prerogative consent to be sought for legislation in 2019 on what further action the Prime Minister should take under the same Article 50 of the Treaty on European Union. The bill before us today could require the Prime Minister to seek and accept an extension in certain circumstances, though it would still be up to the European Council to decide unanimously to agree to an extension with the UK. In these circumstances, and I say this on the basis of professional advice, my ruling is that Queen's consent is not needed for this bill. It will probably not satisfy or even humour the honourable gentleman when I conclude my response to him with what I'm about to say, but it is this. He will not be altogether surprised to know that we did consider these matters, not least in the expectation that they were legitimate issues that might be raised either by the honourable gentleman or by others. I have been advised, I am satisfied with that advice, and I would not rule unless I had asked the questions and got the answers. I have done. I have asked the questions, I have received the answers, and I have been satisfied that it is orderly to proceed and that the answers that I've given in respect both of the money resolution and of Queen's consent are correct.
That is my honourable friend's point of order, Speaker. I just make a small question on the basis of your judgment, which is that as this whole issue of Queen's consent hangs on whether or not, when we triggered, this House triggered Article 50 by statute, whether that statute then covered and assumed the rights under 53, which were the rights to extend and accept that extension, or whether or not that right now still remains a government prerogative under the prerogative powers. There's been a court case this last month, August the 19th. Lord Justice Higginbottom of the Appeal Court ruled categorically that it did not assume such a thing in the case against the English Democrats, and ruled that the government still retained the prerogative rights under Article 53. I wonder whether, Mr. Speaker, you had seen that ruling, and whether or not you would take consideration of that prior to third reading, which is where I gather a final decision would have to be made.
If the right honourable gentleman's point of order, my initial response is that we are guided in these matters by House rules in respect of Queen's consent. It would be a mistake to think that they are extrapolated from or dependent upon judicial interpretation of the kind that the right honourable gentleman has referenced. We have our own procedures in relation to Queen's consent, and what I am saying is consistent with those procedures. I will certainly reflect further on the point the right honourable gentleman has made, but it isn't something which has a bearing on the second reading of the bill. Point of order, Mr. David.
Further to that same point of order, Mr. Speaker, and your comment that you'd taken advice on this, you may remember that the last time that a bill was put through the House at this speed was the Data Retention Investigatory Powers Act, done relatively quickly, supposedly under the pressure of the government of the day needing that law. That act was effectively overturned in court in Davis and Watson versus the Home Secretary of the day, subsequent Prime Minister. And part of the argument that I'm sure affected the judges was the speed with which the House came to decisions on matters of fundamental constitutional importance. Have you taken advice from Speaker's Counsel as to the robustness of the legislation in front of us today in the face of such judicial challenge?
It's not ordinarily the case that the courts look at how we make our decisions. There's quite an established principle of comity with the courts, and that principle is that our procedures are respected, and in turn we respect those of the courts. I will, as I say, very happily reflect further on the Right Honourable Gentleman's point, as upon that of the Right Honourable Gentleman Member for Chingford and Woodford Green, but I'm entirely comfortable that we are proceeding in a proper way. I ought to say to the Right Honourable Gentleman that of course I'm conscious, as every member is, that there are different opinions about the merits of the procedure being followed today, as there are different opinions about the merits of the procedure followed yesterday and the merits of the procedure followed at the time of the bill introduced by the Right Honourable Lady, the Member for Normanton, Pontefract and Castleford. But those are matters of political dispute, not, in my judgment, of rule observance or procedural propriety. We are proceeding in a proper manner. That manner may offend the instincts of some members, but that doesn't make it improper. It may mean simply that it is distasteful to the Right Honourable Gentleman. And I am sorry if that is the case, but it doesn't mean that he's made a valid point of a procedural character.